All right, good evening, everybody. Thanks for tuning in tonight to Hot Topics in Real Estate. I am Rob with the Wachter Group at JPAR Carolina Living. And this is the second in our monthly series of hot topics regarding real estate. We're going to be coming to you once a month, if not occasionally more often, with news that you can use and important information about what's going on in the real estate market and how important topics may affect you and your family in your dealing with your real estate. Tonight, we are going to be talking about distributing real estate in your will and protecting your property rights. And we are joined today by our co-host that you may be familiar with, Kasey Hardt. Kasey is an agent with the Wachter Group and has done some tremendous work with our clients and is co-hosting this series with us. Kasey, thanks for joining us.
Thank you.
And our special guest today is Sabrina Winters, attorney at law here in Charlotte. Sabrina and I have worked together with mutual clients and other things for a number of years now and run into some of the same circles. And Sabrina, thanks for joining us tonight. Why don't you tell us and our viewers a little bit about you?
Oh, well, thanks for having me, Rob. So I do estate planning and probate. I've been doing it for about 20 years now. It does stem from a personal family experience, and I'll touch on that a little bit later. But we help families get their wishes down in writing, and we deal with all different types of assets and make sure that wishes and goals are taken care of.
Excellent. Well, we're glad to have you here, and we hope we get some good questions for you, and we're going to hopefully you and I are going to share some information that might be helpful to some of the people that are watching this. If you're watching this live, we encourage you to add questions or comments as we're going along here on Facebook. If you are watching this in the recording, feel free to send us messages with questions. We would love to interact with you and help you understand these topics a little bit better. So we are going to move along, and I'm going to talk a little bit about today's topics. First, we're going to talk about what is real property, what is real estate, and how is that different than other types of property that you might want to pass along in your estate. We'll talk about ownership rights and how people own real estate. We'll talk a little bit about protecting your property rights. One of the things that I like to say is ask before adding your kids or anybody else to the deed on your house to make things easier. It may and it may not. And what is the proper way to distribute real estate in your will to make sure your wishes are met? I want to start by simply talking about one of the more common ways people own property, and that's when one person owns a piece of property. It's called sole ownership. When that one person owns the entire property, they own all of the rights, the benefits, and the obligations. As that owner, they can sell it, they can lease it, they can gift it. They don't have to ask for anyone's approval. And the owner can pledge that property as collateral for a mortgage or other loan. They have the right to do that. Of course, they have the obligation to pay all the taxes. So sole ownership sounds great. You get all the benefits, but you get all the burdens too. Second type is called joint tenancy. And this is where it gets a little bit confusing. And I want to clarify this. Joint tenancy is when two people own a piece of property together and their shares are divided equally. It could be more than two people. When you have the right of survivorship, essentially what that means is if one person dies, the remaining owners take over the ownership of that property in the remaining shares being equal amongst the remaining owners. If that property were to be used for collateralizing a loan, a mortgage, be sold or gifted to someone, it has to be done in its entirety, and it has to be done with all owners mutually agreeing. If one of the owners dies, of course, their share is divided equally among the remaining owners, and any liens affect all the owners equally. And of course, that means the owners are jointly and severally liable for taxes and expenses. And that's kind of important because what that means is you don't necessarily owe half the taxes on that piece of property. If the other party decides not to pay, you as a joint owner actually owe all the taxes. That's what severally and jointly liable means. The next is more common when you have unrelated people or sometimes business interests in a property, especially if you have rental property. You might have partners. Joint tenants in common is when a property is owned by more than two people. And those ownership shares may be divided unequally. That means one person may own 60% and another person 40%. There may be 3 or 4 people and they can have all different percentages in their shares. In this particular case, each person's share is separately saleable or willable. And if that owner dies, their ownership passes to their heirs as prescribed in their estate. It does not necessarily have anything to do with the other owners of the property. If that property is to be collateralized on a mortgage or sold or gifted, all owners must agree if it affects that individual owner's share. And of course, all expenses are divided according to the share of ownership that each person has in the property. Now, the most common kind of joint ownership is a marital interest. And this is where North Carolina is different than some states. In North Carolina, marital interest is done by tenancy by its entirety, which means both spouses are 100% owners of the property. And it is similar to the right of survivorship we talked about earlier, but in order to enjoy this type of ownership, you have to actually be married. The tenancy is created by marriage and by adding that spouse to the deed of the house. Once that happens, that ownership does not automatically end at any particular time except for death. If there is a divorce, typically that ownership then converts to tenancy in common unless those parties agree otherwise. If one spouse dies, and this is what's most important, then generally the other partner does not have any inheritance or taxable event as long as they stay in that property and they continue to own it as their spouses. At this point, we're going to talk just for a couple of minutes about, now that we know how you own property, what do you do with that property if you want to pass that along? What are the proper ways to do it, and what are some of the pitfalls? So I'm going to turn this over back to Sabrina. And Sabrina, we'd love to hear you talk about these particular topics.
Awesome. Thanks, Rob. I can't see the screen on that little slide. I don't want to miss any points that we wanted to make. I don't know if it's screen shared. While you're looking, so I just want to give a little bit of background so that the pitfalls make a little bit more sense. What you talked about is super, super important when you are talking about estate planning. So when you're doing estate planning, you have to know your assets, and real estate is an asset that is often overlooked. Because people just assume, well, I own it with somebody, they're going to get it. Like they assume that with a lot of the other assets. So when you're doing your wills or your trusts, you really have to specifically talk about all of your assets, including real estate, because the ownership makes a big difference in how that is allowed to be distributed and ultimately how it is distributed. So when we're talking about having a piece of real property and you own it with somebody else, that ownership is on the deed. That's number one. You have to look at the deed to see how the ownership is so that you can figure out what you're allowed to do with transferring it at your death, as well as what you're allowed to do with it while you're surviving. Some of the pitfalls that I see often with clients coming to see me is adding a child to their deed. I know that the ultimate goal was that I want my child to have it anyway. But when you gift a real piece of property or even any other type of appreciable asset, you're going to take away that step up in basis that that person would have been afforded if they inherited it from you after your passing. Now, I could do an hour on step up in basis, but I do want to just cover it briefly. That means when you pass away and you inherit something, you get the benefit of possibly paying less in capital gains when you sell it, because that appreciated asset was higher on the date of death than it was when that person purchased it. So it is a benefit to the person that you're giving it to, if that person decides to sell. And so when you're adding somebody to that as well, you have to remember that now you are taking on all of that person's creditors. So not only knowing what your ownership is and what you're allowed to do, but realizing that you're probably not doing them any favor whatsoever by adding them, but you're also possibly hurting yourself in the future with their bad credit history. We think that we know everything about our kids. We don't always know what's going on in their personal life and their marriage. You have to be careful when you add them because their creditors now become your problem. So being very careful when you're doing that is super, super important. You know, and the other thing is when we talked about tenancy by the entirety earlier, Robert mentioned that it's a very special ownership of property. North Carolina doesn't really allow a spouse to do much with inherited real estate or gifted real estate without having some level of say in it, whether it's signing off or something. So adding a child who is married might have been the right choice in the long run, but you later find out that maybe that spouse was required to sign off on something. So you don't want to have that as a possible litigation in the future. You know, I had a client call today, and my client added the daughter to a very expensive piece of real estate, added her to the deed. Well, the daughter is now in the middle of a separation, and that has caused so many problems. She can take herself off, but now they're in the middle of a separation, so that looks bad, and it could go against her. And he wants a piece of that very expensive property. So be very, very careful. There's a lot of things that could go wrong with that.
I've had a very similar situation come up, Sabrina. It's one of the reasons I asked you on this show to talk about this topic. One of the clients that I worked with last year had gifted or put their kids on the deed many years ago as part of a poorly done estate plan. And they decided they wanted to sell the house and take the money and move into a retirement community. And they were told that initially that they didn't any longer own the property. They didn't have that money. And they went to their son, and their son had also been going through a terrible divorce, and it tied things up a little bit. And we were fortunate we were able to help them extricate themselves from that. But yeah, it can affect people even while they're still living.
Yeah, it's pretty dangerous not to really consult with an attorney before doing that, because to my next point, you may not be able to take them off anymore by yourself. You're going to require them to sign themselves off of the deed. So if somebody was to be given $1 million home on a deed, you think they're going to take their name off that easily? No. It doesn't matter what the relationship is, it is likely that they're not going to want to come off. And you lose that right to be the sole decision maker. So whether you owned it alone or you owned it with a spouse and then added a child, you don't get to make all the decisions anymore. So when you want to refinance, they're looking at everybody that's on that deed. When you add somebody, you have to ask them to take themselves off. That means they have to sign a new deed, taking themselves off as an owner. It is very difficult to get somebody to do that, especially with the situation that I was presented with yesterday. And when you think about it, a lot of the times that I see the gifting is in two situations. They're a married couple, and they, in their minds, are getting to the point where they want to make sure that they're not losing assets and that their kids get everything. They don't understand fully that there's another way to do that. It's through your will or through a trust. So their level of being nervous and scared is at an ultimate. And so they think, I just want to add my child's name. And when they go to an attorney and they're not counseled properly, they don't know all the pitfalls. And number two, when I see it, most likely is somebody has lost a spouse and they are retired and they're scared because now they're alone. They may have been the one that took care of everything except the finances. And they think by adding a child, they'll be able to get the help. And that goes across the board with a lot of assets. I've seen them add children to investment accounts as owners, when if they were counseled the proper way, they would have been told, you can do that with a power of attorney. So there are other ways to get to the end result without having to get to the end result and the possible issues, that are associated with that.
Well, that probably brings us to the next slide then.
Yeah. So there's a lot of ways that you can transfer assets properly without having to go through the pitfalls. The biggest thing is never do it without getting a consultation from an attorney who knows what he or she is doing. It is invaluable to make sure that you're getting all of your questions answered and all of the possible outcomes explained to you, so that when you're making your decision, you know what you're doing, you understand why you're doing it, and you ultimately understand the end result. So what we do for clients is we, create last will and testaments or revocable trusts. Those are the vehicles that are supposed to be created to transfer assets. When you don't have this in writing, North Carolina has decided for you, you have no choice on who's going to get your assets. And it is very dangerous to plan that way. I settled an estate a couple of years ago. Husband and wife were in the process of a separation, and they had signed off on the rights to each other's estate. Nobody had a will. What happened was the surviving spouse had to share their home ownership with his two kids, who were not adults, they were minors. And so he needed to go through a guardianship for trusteeship through the court in order to sell the house and divide the proceeds amongst the three of them. Now, had they planned it out properly, that's likely not what they would have planned. So you have to be careful that you don't let North Carolina decide who gets what and under what terms. Putting it in writing is going to really safeguard any issues for family later. And real estate's treated differently too than a checking account or an investment account. And you want to be careful of that too. It's much harder to undo something with a real piece of property than it is with an investment or a checking or a savings account. Then for clients who are adding that extra level of protection, you can transfer your real estate through an irrevocable Medicaid trust. And simply put, it's an added level in estate planning so that you can protect certain assets from requiring to be used for skilled nursing in the future. It's a fantastic vehicle. It does so much for clients, but it can also hold real estate, and it can also be distributed under your terms and not North Carolina's. When there is a gift of real property, which is very, very rarely used, it is always and should always be encompassed around a proper estate plan, that everybody understood why they were doing it, everybody understood the ramifications, and everybody prepared for those ramifications in the future. Nothing was going to be a surprise, and it was all spelled out within their will, their trust, and their plan that they were working on with the attorney. But a gift should never be done willy-nilly without really knowing what the entire process is for and what the outcome is.
What I would imagine in today's world, we're in a DIY world these days, and people watch videos like this or how-to videos on YouTube and find websites that have some great advice. Can you talk to for just a minute to some of the dangers of trying to do this yourself?
Sure. I actually had this conversation. I have it a lot. I had it this afternoon with a potential new client. And we had our conversation, and I understood her concerns. I understood her fears. She understood I had the tools to make sure that she didn't have those fears anymore. I had the solutions for her. And at the end, she says, well, I'm going to just check with the legal plan that my employer has, but I'm going to tell you this, all they did was send me documents to fill out, and I'm supposed to send it back, and I really don't even know what I'm doing. And I said, is that really worth your son being in litigation later? Because it was easier to do that process than it was to get it done right. You don't get to ask questions when you do it yourself. When you do it online, you can ask another lawyer on that service that's provided, but it's also still very dangerous. Your attorney that's doing your estate plan has got to know everything about you. They have to know your fears, your concerns, the dynamics with the children, the dynamics if it's a blended family, what your assets are. If you don't have that ability to ask the questions, it's not going to be worth it, even if it's completely free. Also, getting them signed, witnessed, and notarized properly is often the case that it's done wrong. When it's not signed properly or you don't have the right witnesses, it's not going to work when you need somebody to step in and use that document. So if it was completely free, what's the difference then when your family's still fighting and nobody knows where your assets go because your estate's in litigation? It's that fear that you're going to do something wrong. I've seen them drafted where parents accidentally disinherited their future born children. They only provided for the 2 children they had at that time in their will. And then they had more kids who were not included because the program only asks them questions based on the answers they're given. There's no processing of information, and there's no examples, and there's no explanation. So to me, that's the biggest. You need somebody who understands what they're talking about and who can provide you solutions for your particular situation. Everybody is different. My client in the morning may not care that his son has everything when he's 25. Well, we're going to plan one way. My client in the afternoon may have a big concern for his 30-year-old, and we're going to plan that a different way. But without the ability of a conversation or really information gathering and rapport, it's just not going to be the best plan.
I got you. Thank you for sharing that. I would imagine, and this is a difficult topic to talk about sometimes, but, one of the real problems is sometimes you don't know that you made the mistake until it's unfixable, right?
Yeah.
Unfortunately, once someone has passed away, they can't go fix the problem. So. And
that person can't fix it. And oftentimes the family is stuck in litigation. While imagine it happening now where the real estate, and real well, Rob, it's fantastic right now. Imagine having that happen in a market like this where you've got several buyers that want to buy that property immediately and they can't because it's stuck in litigation.
Mm-hmm. It's not good for anybody at that point.
No.
Mm-hmm. Excellent. Well, that concludes kind of our formal presentation today. And Sabrina, I appreciate you going through that with us. And we're at the point where we'd like to talk to our audience and see what kind of questions have come in. I've got a couple in front of me, and we're going to turn for just a minute to Kasey, who I know has been collecting questions, and Amanda, who's been engaging with people online. So let's just take a minute and see what Amanda has compiled. Okay?
I have some questions as well.
Okay, so Amanda doesn't have any at this point, so we'll go to Kasey. Kasey, have you found any questions that have come up?
Yes, so one of the questions that came in was, can I write what I want as a will and just sign it in front of a notary and it will count?
I'm assuming that's for me, and I'm going to say that it depends. So there is a part of the statute that allows handwritten wills under very certain circumstances, and it usually has to be followed by an imminent death and that you knew. 99.9% of the time, a handwritten will in front of a notary is not going to count. We have to have 2 witnesses in North Carolina. So the person creating it has to sign it in front of the witnesses and the notary. The witnesses, 2 of them, not related in any fashion to the creator of the will, nor are they a beneficiary in that will, have to sign the documents in front of the creator, and then the notary has to be there to see everybody sign. That is a formal executed will under the statutes of North Carolina. There's a lot of other exceptions that come from the statutes and also some from case law, but 99% of the time, it's a will that is notarized, witnessed by two people, and signed by that person creating it.
Mm-hmm. Great, thank you, Sabrina.
And we have a follow-up to that question, if that's okay.
Yeah, of course.
What if I don't have a will? Will everything just automatically go to my family?
Again, it depends, but probably not. When we talked, Rob had those slides up about ownership of real estate. That goes for ownership of assets too. You can't give away something that you don't own. So you may only own part, half, or you may own it all. It all depends on the ownership. For the most part, people who wait to do their wills and think that it's going to just go to their spouse and their kids likely are not going to be correct, because North Carolina could care less about how old your kids are, what assets you have, what special needs your kids have. They don't care. The way the statutes are written, they're getting rid of your assets based on who is alive at the time of your death. So it is very dangerous to plan that way. I would never do that. I would just always make sure I'm getting something in writing so that you can assure yourself that what you've decided is what's going to happen, not North Carolina.
Mm-hmm. Great. I've got a viewer that asked the question, can parents penalize kids if they challenge the validity of the will?
Yes, if they create a will or a trust, and in it, it's got the section that says, listen, if you contest that you didn't get anything and you don't like what you got, then you're getting nothing. They're not typically or commonly upheld, and I don't do estate litigation as part of my practice. It's more of a roadblock to litigating an estate. So if somebody sees that and is a little, maybe I shouldn't do anything, at least I'm getting something. If that keeps somebody from taking the estate to court, then it's done its job. But that's more of for a detailed question for an estate litigator to really delve into that. But you can put something in writing inside your will or a trust to kind of try and avoid that.
Gotcha. Okay. Kasey, do you have any more questions from any of your audience there?
Yes, I think this will is really throwing people off. I have another one that's saying, in your experience, when there is no will, is there a concession order of who gets what? So I think they're asking, does it usually go to the spouse? Does it go to one kid? What does the state usually regulate with that?
Well, again, when that person passes away, the statutes are going to look at who is alive. So they may look at a spouse. Do they have children? They might look at a spouse. Do they have children and a predeceased child who has their own kids? Are the parents of the decedent still alive? It varies, and it's dependent on who is alive at that time. And that's where the intestate statutes come in. And that just means that person died with nothing in writing, no will and no revocable trust. So I can't answer it specifically on who would get it. We have to see who passed away and who was alive at the time that that person passed away, and then check the statutes to be 100% certain.
Okay, super. It appears, well, actually we have one more pop up, and I'll actually take this one. Someone has asked, what happens if someone lost their deed? Because I believe you mentioned earlier, having the deed. There's good news for that. In today's world, deeds are recorded at as a public record at the Register of Deeds office, and you do not need to have your own copy. The county has their copy. So you don't have to worry about that. We can always, in fact, today, in most cases, we can recover that online right from our own offices without having to go anywhere. Okay, I think that is all that has come up here. Sabrina, I just want to close out today by saying thank you very much for taking your time tonight to share with our viewers the answers to these questions and to go over this topic. And again, if you're watching this on a recording, right now, the contact information for Sabrina is on the screen, as it is for Kasey and myself. If you have questions or comments, we encourage you to go ahead and put them through to us right here on Facebook. You can share this with other people if you feel that you know someone that would benefit from this. And we appreciate any feedback that you have on what things you'd like to hear us talk about in some of our future shows. So if there's nothing else, I'm going to wrap up and just say thank you all for being here tonight, and thank you all for watching. And
Thank you,
again, I'm Rob
Rob.
with the Wachter Group, and have a great night.
Thank you.
Invite. Thank you so much.